Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. We are coming to an end of our important legal maxim series and I hope you are finding this useful. I have already created a consolidated document for all the important legal maxims. You can download that from the description below. This is our part 19 and the first legal maxim today is jus. This means a right that is recognized in law. You may have heard this term as a part of other maxims, jus ad rem, jus in re. Therefore, jus means the whole body of law, a particular system of law, any legal principle, right or power. Coming to jus ad rem, jus in re, this means a right to a thing or a right in a thing. Jus ad rem is a Latin term which is used in civil law, meaning a right to a thing, that is, a right exercisable by one person over a particular article of property in virtue of a contract or obligation incurred by another person in respect to it, and which is enforceable only against or through such other person. While on the contrary, jus in re is a complete and absolute dominion over a thing available against all persons. Therefore, jus ad rem is a type of right that arises from another person's duty and is only valid against that person. It is an incomplete right to a specific property, while jus in re is a complete right to a thing. One example of jus ad rem is a mechanic's lien. If a mechanic repairs a car and the owner fails to pay for the repairs, the mechanic may have a right to the car as security for the debt. This right is only valid against the owner of car and is incomplete until the debt is paid. Another example could be a mortgage. If a borrower fails to make payments on a mortgage, lender may have right to foreclose on the property. This right is only valid against the borrower and is incomplete until the foreclosure process is complete. Let's take an example for jus in rem as well. Let's say David owns a house. This house exclusively belongs to him. He has right in rem with respect to the house. So nobody can interfere with his ownership of the house. No one can disturb his right in rem. Coming to the next maxim, jus naturale. This means natural justice. Jus naturale is a philosophical system of legal and moral principles that are based on human nature and moralistic ideals of right and wrong rather than on legislation, judicial action or statutes. For example, the idea that individuals have certain natural rights such as right to life, liberty and property, these rights are not granted by government or laws but are inherent to human beings. The next maxim is justitia nemini neganda est. This means justice is to be denied to no one. This legal maxim means that all persons must be afforded their legal rights without discrimination. There are similar maxims with the term jus, jus in rem, jus in personam, jus necessitates, jus scriptum, jus non scriptum. Jus necessitate means right of necessity. It's a legal principle that allows individuals to take actions that would normally be considered unlawful in situations of extreme necessity to protect themselves or others from harm. It's a legal defense that can be used in IPC to justify an act that would otherwise be considered a crime. Jus scriptum, that means written law. Jus non scriptum means unwritten law. Jus in rem means a right against or in respect of a thing. As we have seen, jus in re, jus in rem means a right in a thing, absolute right over a thing. Jus in personam means a right against or in respect of a specific person. Jus in rem is available against the world at large, while jus in personam is only available against particular person. Coming to the next one, lex dabet remedium. This means the law will give a remedy. This maxim means that the infringement of a legal right necessarily entails a remedy appropriate to the violation. Sometimes this legal maxim has another term over here, lex semper debet remedium. That also means the law always gives a remedy. The next maxim is lex dilationis abhorret. This means the law abhors delays. This maxim means that the unnecessary delays in the administration of justice dilute the quality of that justice, which is equivalent to justice delayed is justice denied, and may justify an award of monetary damages or in extreme cases a default judgment to the injured party. Another legal maxim is jus quagem. This means compelling law. So this we skipped earlier. These are all the legal maxims in this video. I hope your preparation is going on well. You are fully prepared for the upcoming SEBI legal exams. If you have any queries, any doubts, you can write them down in the comment below. Thank you so much for watching this video. Subscribe to our channel. Stay tuned.